Well, Judge Everett really wanted opening statements to begin in Donna Adelson's case today, Thursday at 1 p.m. in the afternoon. But as we saw today, jury selection just took way too long, and it is actually still going on as I am recording this video at around 5:30 p.m. Thursday afternoon. So we'll see if they finish up with the jury selection process today, and then perhaps even Friday morning go right away to opening statements. But it could be that the jury selection process will continue into Friday morning, and then at some point later in the day go to opening statements. So that is what we're hoping for, and we will be there right with you Friday morning as court starts. So whether it's jury selection and they're continuing to live stream that, or whether it is opening statements, we do plan to be with you beginning Friday morning. So I do want to talk about the questions that were asked by the prosecutor and the defense. And the reason is that this doesn't always happen in every case that you're able to see, that the public's able to see the jury selection process, the questions specifically that the lawyers are asking the jury. And some of the questions may feel to you not so important, and you're not sure why they're asking certain questions. Well, as lawyers, you actually have a little bit of a better insight into why they're asking certain questions, which I'd like to point out to you as we go through some of the questions that were asked. And I think that both sides did a pretty decent job of asking some of the questions. And also you start to see laying the seeds, laying the foundation for their own specific case. So that's also something that you're doing during jury selection. You're not just trying to figure out whether this person can be impartial, but you're trying to already lay the seeds, lay the foundation for, plant the seeds, better said, then that this is an argument that you may be making to the jury, and you want to see how they're going to be reacting to your arguments. So there's a lot that goes into it, a lot behind the scenes, which sometimes to a casual observer, they won't understand the depth behind the questions, but there's usually, definitely the good attorneys, there's a lot of thought that goes behind some of these questions. So let's start with Georgia Koppelman's jury selection questions. So she started off with asking if anyone is a supervisor or a leader or a manager at work. Then what she wants to know if they have any sort of skill at like being a leader or supervisor. And the reason for that is that you always want to know who the leaders are in the jury. Why is that important? Because very often the leaders are the ones who are commanding the conversation. They're taking over the conversation, or they're directing the conversation, or they have strong opinions and they're able to explain their opinions. They're able to also bring people over to their side. So they're very influential, generally speaking, leaders and supervisors and managers. So you want to right away identify them, and you also want to see whether by some of the other questions that you ask, you want to get some of their reactions to see whether they are going to be more sympathetic to the prosecution or the defense. And the same thing would go in a civil case. You want to see whether they're going to be more sympathetic to the plaintiff or the defendant. So the first thing is identifying who the leaders are, which is the first thing that she was doing, which is, again, something nice to see that she's using this strategy. Okay, then moving on, she moved on to the burden. And this is something I also always stress, that whether you're the prosecutor in a criminal case or whether you're the plaintiff in a civil case, you always want to embrace your burden. You want to show the jury that you're not scared of your burden and you're happy to embrace your burden, and you are going to prove your case by whatever the standard is in your case. So in the civil case, preponderance of the evidence, or in a criminal case, beyond a reasonable doubt. You want to show them you're not scared about that at all. And that's what she did. She said that it is her burden, and the defense has no burden at all, and we have no problem with that. Essentially, that's what she's saying. She didn't say that, but she could have said that. But what she was saying is, this is my burden. This is my burden, the state's burden. We're going to prove the case to you. The defense has no burden. Donna Adelson doesn't have to take the stand, and it's all my burden, and we're happy to do that. Then she also went into reasonable doubt. What does it mean, reasonable doubt? And again, this is important as a prosecutor to explain what reasonable doubt is, and that you're not scared of what reasonable doubt is. Yes, it's a very high burden, but we're going to prove it. No problem at all. And then she actually gave an example. So this is an example where she gave, and she said, if you go, she asked one of the jurors, you went and you parked your car in the car garage or wherever you parked it, and you locked your car, right? And there was maybe security there. There's no one lurking around that you found. Do you have any reasonable doubt that your car is not still there? Well, you don't have any reasonable doubt because, you locked your car. Everything should be good. So that's an example of what beyond a reasonable doubt is. If I'm able to prove to you that you parked your car, you locked your car, there was security there, no one's looking around, that's good, that's fine. But let's say there would be somebody looking around. Let's say you let somebody know, by the way, the keys are in the engine, or there's no security, or you parked in a bad neighborhood. Well, then, you may have start to creep in some reasonable doubt. So that was just a nice example that she's giving them about what reasonable doubt means. Another thing that she stressed was that you have to judge the facts, not the person. And again, this almost sounds like she's sticking up for the defense. This is almost like, wait, are you on the wrong side? Are you going to try to say how Donna Adelson is just this terrible person? And this is the point that she's making, is that no, I don't care that you're not going to judge the person. I don't want you to judge the person. And maybe the judging the person will actually make you more sympathetic because she's a grandmother. So it kind of cuts both ways, where she's saying, look, it doesn't matter who's really sitting in that chair. What matters is the facts. What matters is the evidence. That's what I want to start focusing you on, and not get taken away by her looks or by your sympathy or feeling bad for a grandmother having to go through this. So that can cut both ways, and that's also something that she got right in front of. Also, something that you always have to stress in these criminal cases is that as the jury, you're not to consider what the sentence may be in this case. That should be completely out of your consideration. Whether the sentence she's facing is 1 year in prison or probation or no prison, or a fine, you shouldn't be concerned at all with what the sentence is going to be in this case. That's, again, something that she stressed. Then she also wants to know if anybody has issues with the criminal justice system. Why is that? Well, a lot of times if someone's skeptical with the criminal justice system, that may be someone that, as a prosecutor, you don't want on your jury. You don't want, because if somebody's already going to have certain doubt or be skeptical about police work or law enforcement or prosecutors or DA's office or states or these things, prosecutions. So that's something that you obviously want to know and find out. And that's why you also ask questions like where she followed up with, does anybody have any bad experience with law enforcement? We want to know, what was that like when you got pulled over? Was the police officer polite? Was he respectful? Did he jump to conclusions? These type of things where if somebody had a bad experience, as a prosecutor, you want to get out and know that, so that maybe you'll use one of your preemptory challenges on one of these potential jurors. Also, she stressed this fact, which again, you may think that she's coming from the defense, but this is a good thing. This is a part, what I always stress is that if there is something that the defense could bring up, you bring it up. As a prosecutor, if it can hurt you or can make you look bad or whatever, even if it's not going to make you look bad, but it's a good point for the defense, you want to show the jury you're not scared about it. So one of the things that she said is that everybody would agree with me that you don't automatically believe police officers. You don't automatically believe law enforcement just because they have a badge, right? Everybody understands that. And also, as a prosecutor, we have no problem if you use a level of skepticism when it comes to law enforcement or police officers. So that was, again, something that was very good that she pointed out. Look, I'm going to be calling police officers, but I don't want you just to automatically believe them. I want you to use your common sense and weigh the evidence and just, look at their mannerisms and how they're testifying. I want you to do all these things. So that's kind of what she's laying the foundation for by saying you shouldn't automatically believe in law enforcement. And law enforcement could make mistakes. That's true. They could make mistakes. Everyone's human. Even if you're wearing a badge, you're wearing a uniform, everyone could make mistakes. And she's getting in front of that as well. Also, this is another very, very important part about this case, because we know that we're going to be hearing evidence about the bump. If you've been following this case, you know everything about the bump. Well, that's a police officer acting like he's not a police officer. He's undercover. So she wants to know, does that make anybody feel uncomfortable? Is that not fair? Is it unfair that you think that a police officer is going to go undercover? Did I say uncover? Undercover, and try to arrest criminals? Do you think that that's a problem? And she wants to know, just be honest with me. If you think that that's a problem, let's just have a discussion about it. And of course, then she's making a mental note or actual note saying if a juror has a problem with that, then I may want to excuse that juror. But also, it's important to get out of that, even if it's not just that this juror. Let's say you have one juror who has a problem with it, right? But even if you're just going to dismiss that juror, you still want to have the conversation, because having the conversation a lot of times will convince the other jurors that are still there that there's nothing wrong with it. So you're able to make a type of argument about why there shouldn't be anything wrong with having police going undercover with this juror. And also you're going to know that this juror is someone that you have to dismiss. So these are all part of the tactics, is that you want to engage conversation so that, number one, you can start, again, planting the seeds, making these type of arguments, which then you don't have to make for the first time in opening or closing. and you're already planting the seeds with the juror. So that was a good part. Again, you want to bring out the undercover part, and also just start letting the jury know there's nothing wrong with that. Even though somebody went undercover, there shouldn't be anything wrong with it. If you want to have a discussion about it, let's have the discussion right now. And then later, when I say, okay, this officer went undercover, you won't have a problem with it. Okay. Then she gets into premeditation, because this is a murder case and they have to show premeditation. So how do you show premeditation? And this is, again, as the lawyer, you don't want to lecture to the jury. You're going to be doing that during opening statement and closing arguments. Jury selection is supposed to be conversational. You want to leave it open. And then as you're having the conversation, you say, well, what about that? What about this? What about the other thing? What do you think about this idea? So that's, again, something that you saw a lot by both sides, by the way. They both, I think, did a good job in getting the jurors to get into conversation. They were picking on certain jurors. They're saying, okay, juror number 26, can you tell us about this? Juror number 11, juror number 14, whatever it is. But the point is that you're trying to get them into conversations, which is exactly what they both did. So this is what Georgia Kaufman said. She did. She said, what does premeditation mean? Let's have a discussion about it. And then she says, well, how do I show intent? Right? Premeditation is that you're planning. You're planning this murder. Well, how would I show that somebody had the intent to murder somebody? What type of evidence would you need to see? What type of evidence would you present? If you're the prosecutor, if you or me, what type of evidence do you think would be significant for you and convincing for you? So how do I prove all these things? And then she suggests, well, what about conversations that people have? What about motive? What about circumstances of how the person was killed? Sometimes that can be considered as premeditation. What about financial records? Even one of the jurors, I think, suggested financial records. Great. If you get a juror and you're going to introduce financial records, that's wonderful, right? So this is part of the thing that, oh yeah, we're connecting here. We're connecting with the jury. And when I come back and I say, look at these financial records, remember, and you look at that juror who said, yeah, financial records, that's right away. Boom, you got it. So that is another thing that she brought up. Also, another important part is that since they're going to be hearing about other people that were involved in the murder and the people that are maybe have already been convicted, like Charlie Adelson is going to be testifying in this case, seems like. So can you set your feelings aside about the other people that were convicted in this case and just judge this case for what it is? Also, she pointed out the fact that you don't have to actually pull the trigger to be convicted of a murder. And this is where she also started talking about the idea of principle. And we keep hearing about principle, and so let's just explain what it means in this case. So in this case, you're able to charge Donna Adelson with first-degree murder, essentially, with conspiracy to commit first-degree murder or solicitation, all these things that go into whether a person can be charged as a principal. And even though you're not the person who's pulling the trigger, but since you did an act, and your intention of that act was to help with this murder, help carry out this murder, encourage the person, entice the person, you're helping the person who actually is going to pull the trigger. So then you can be charged as a principal. They want to make this very clear that if you are there doing an act, any sort of act that's to help the person who's going to pull the trigger, so then you can be charged as a principal, just like the person who pulled the trigger. So that was another point that she wanted to point out. Now, she asked, what's a conspiracy? Again, she doesn't want to lecture about what a conspiracy is and what it says under the law. She wants to get into the conversation and then, again, lay the seeds, lay the foundation, plant the seeds. So she said, what is a conspiracy? Can anybody tell me what a conspiracy? What do you think a conspiracy is? Who would be involved in a conspiracy? How would I prove a conspiracy? So, for example, which let's say many times when you have a conspiracy, you don't have three people get together in a room and lay out exactly, okay, let's do this. Let's put it down on paper, and your role is going to be this, my role is going to be that, everything beautifully laid out and stated that way. Sometimes you need to bring in circumstantial evidence. You don't always have evidence of what people were talking about in their private room, but you do have some other circumstantial evidence, like the cell phone records or what they said in code or where they were at certain times. So all that is going to play into being able to prove a conspiracy. Another very, very important part that she brought out is the fact that this murder happened 11 years ago. And now we're charging somebody. So this may be an argument that's brought out by the defense saying, oh, it took them 11 years to charge, to bring this case against Donna Adelson. Some of you may be thinking about that. Or even if the defense doesn't make any mention about it at all, but if the jury is thinking about it, then the jury can be thinking, hey, why did it take them 11 years? So this is something, again, that Georgia Kaufman wanted to bring out. And that's why she said, does it matter how long it takes to make an arrest? And I think Again, some of these points could have been elaborated on. For example, at this specific point where she was saying, does it matter how long it takes the police to make an arrest? She could say, should the police ever stop investigating a case just because it's already 2-3 years past the crime? Should the police just do that? Should they just stop working on a case, even if they get additional evidence? Should they do that, or should we continue our investigations until we actually locate all of the people involved in the case and bring them to justice? Is that a better way about this, or is that a worse way about this? So I think it could have been explained a little bit more, but again, it's an important point to bring out, that just the fact that it takes a long time to prosecute a case and to eventually charge somebody, it shouldn't change your decision on the case just looking at the time it took. Another part, that there's going to be a cooperating co-defendant here. We know Luis Rivera is going to be testifying on behalf of the state. So there's a cooperating co-defendant, and yes, he may not be a savory witness. He may be unsavory, and you may not like him. You may not want to have coffee with him. You may not want to talk to him. He may be a gang member. But does that mean that he's automatically not saying the truth? Right? So that's an important part that she has to get out there, because this is a very important part of her case. She has to get the jury to believe Luis Rivera. So she wants to say, look, the guy's not the greatest guy. He's in prison. He's convicted of a serious, murder, part of this murder. And, but he's cooperating, and it could be that he's telling the truth. So if you're able to weigh that based on all the other evidence that you see, so then you should be able to still believe him if it makes all the sense. Okay. And then she talked about inconsistencies, which again is such great points that she's making here. Let's say you find some inconsistencies with different witnesses. You're almost always going to have inconsistencies, right? So certain inconsistencies actually matter. Certain ones don't matter that much. And that's a point that you wanted to make with the jury, because you will find any defense attorney, any attorney out there, I think, who's worth his salt, is going to be able to find, or her salt, they're going to be able to find certain inconsistencies with witnesses. That's our job. Now, the question is, do those inconsistencies make a difference? And of course, lawyers on the defense side are always going to blow up these inconsistencies and make them seem like they're just Mount Everest and they're impossible to get over, and therefore you have reasonable doubt. Well, Georgia Koppelman wants to get in front of this, and she says, you will be seeing inconsistencies, but you have to remember, certain inconsistencies don't make such a big difference, right? What color suit I was wearing yesterday, does that really make a difference whether I'm the prosecutor or not? No, right? We know it was you. We know you were here yesterday, so it doesn't really matter what color you were wearing or what color your co-counsel was wearing. It doesn't really make a difference. Okay, so that was another point that she brought out. And then she also said, look, anybody can be a killer. Does anybody have a trouble with convicting a grandmother as a killer? If the evidence proves that she was a killer and she's a grandmother, would you have any issue with convicting her just by the fact that she is a grandmother? She also spoke about the divorce, that there's divorce, there's custody battles. Have you been involved with them? Any of the juror members have been involved with these messy proceedings. But everybody would agree, even if you haven't been involved, that they can be very highly emotionally charged. And that can make people act a certain way or get a certain feeling towards another person. And they can be very emotional, when emotions can cause a person to, perhaps even murder somebody, so like that's the idea. It can definitely provide a motive. Then the final question I really, really love, because it's a question that I always ask myself. So anytime I see another lawyer asking some of the questions that I ask, I always think that it's a great idea. Well, the final question that she asked, and I usually ask, there's always two questions that I finish off with, but this is one of them. One of them is that, is there anything that if you were me, right? If you were standing over here as the lawyer asking you questions that you think that you would want to know about yourself, like, what do you think that I didn't ask? What is there something about you? Is there something about you perhaps that you think somebody in my position should know that I just don't think to ask? Is there something about your experiences? Is there something about you, your personality, your family situation? Is there anything about you at all that you think would be important for someone like me making a very important decision, whether to keep you on this jury or not? Is there something that I should know? And that was really her last question, which again, I think that's a great question, because, a lot of times there may be something that you have that the lawyer's just not asking. And, it's something that you think is important. And if you're an honest, open and honest person, you'll tell the jury, you'll tell the lawyer. And by the way, I've been in cases where someone will offer some information. Yes, this involves this type of situation. And I think you should know that I was involved in, something similar, or a friend or whatever. And I thought maybe you should know that, so, and that's important. I do want to know that. So great question that she asked. Okay, then moving on to the defense. So we had Joshua Zuckelman. He got up for the defense, and he said, "Okay, first of all, you have to understand, right? 12 heads are better than one, right? You got 12 people there on the jury, and I think the point here was that the state is only two prosecutors, one prosecutor, and you're 12 jurors, and you're 12 independent peers that are going to be judging this case that we need to judge this case. And there's three alternates also, but there's ultimately going to be 12 people deliberating, and 12 heads are the best. And they're better than one, maybe better than the judge. So maybe that's the one that he was talking about. But the point is, I think the point's the same, is that we need all of you to be judging this case, and that's the best way to go about it. It's not perfect, but it's the best way to go about it. Then he spoke about implicit bias, which is becoming a little bit more popular to talk about. Do people have certain biases? So, for example, the examples that he gave was, when you came into the courtroom, did you think, oh boy, I wonder what she did, or I wonder what she was accused of doing? Do you jump to the fact that she is sitting there by defense counsel, by the table? Do you automatically assume, oh, did she do something? Or, oh, maybe she's being accused of doing something, she didn't do anything. Just to give that difference of the mindset. He also spoke about this later on, but let's go through one thing at a time. He asked them if they get claustrophobic. Like, are you going to be in a room with 12 people and you're going to get claustrophobic and you just want to get out of there? Okay, so that was, all right, just a fair question. Also, he said, is there a difference between saying, I think, when a witness says, I think I saw something, or that I actually did see something? So he wanted to make that straight, that there's a difference in the level of credibility when a witness says, I think I saw something, or I know that I did see something. He also asked, is anybody in the juror naturally skeptical? Which, again, this is exactly what you want as a defense. You want someone who's naturally skeptical. That's exactly who you want. So if somebody says, yeah, I'm skeptical about everything, so then great, that's someone that you want on your jury. You want them to question everything. You want them to be skeptical about police work and prosecutions. You want that. So that's a good question to see if anyone's just naturally skeptical. And then again, he asked a nice open question. He said, how do you determine if someone's being honest? How do you determine that? In your regular lives, how do you determine that? And, one of the ways you can determine that is by looking the manner in how they testify. Are they consistent with other witnesses? Is it consistent with your common knowledge, your common sense? So that's just a good way to engage people with conversation, so that when you bring up those points later and say, remember, you told me, that you can tell when someone's not being honest if it conflicts with other witnesses, or if conflicts with your common sense, and then you make that argument, it's just that much stronger because you already laid the foundation in the jury selection. Okay. And then he said, okay, what about misunderstandings? How would you correct misunderstandings? Or how do you not make sure that you may have misunderstandings? And he brought it to you avoid assumptions. Don't make assumptions. Don't automatically make assumptions about certain things. Repeat it back to people. Have conversations. Have somebody else confirm with you, and that way you have clear what each witness said. Or if you're looking at exhibits or documents, to make sure that you're avoiding assumptions and confirming that you don't have any misunderstandings. Another question, which is very important about this case: do you know, definitely for the defense, do you know people who keep large amounts of cash on them? Meaning, is there some sort of level of distrust with the banking system? And here is where he's kind of playing the grandmother card right here, because he kind of said, and this is also, a lot of attorneys like to do this. I like to do this also, when you kind of throw in some personal anecdotes, because number one, it makes it more personable with the jury, but also there's just a different level of credibility. When you say something to the jury, I think people shouldn't trust the banking system, or I personally don't trust the banking system. That's one level. But if you can always blame it on your mother or your grandmother, there's always just a different level. Like, it's like a level of, okay, you got this from somewhere. And, we look up to older people, like as people with authority, and it resonates with a lot of jurors. So this is where the defense attorney did a good job saying, my grandmother, I can she didn't trust so much the banking system. And she's trying to, again, paint Donna Adelson as that type of person who always likes to keep a lot of cash on them, and because that's what happened in this case, right? There was a lot of cash that was being divvied out. So that's just something that, again, you see that he's laying the foundation, planting the seeds for arguments that he's going to be making and evidence that they're going to be hearing. Okay, so another question, because we know that there's going to be some conversations that were recorded. If, let's say, you get a personal phone call from somebody, this is another question that he asked one of the jurors. If you get a personal phone call from somebody and there's people around, what would you do? And you have to talk privately to this person. And what he's getting at here is that you would essentially talking code, right? And he was trying to get her or be vague, be ambiguous, try to be careful because you're around other people, so you don't want them to catch on what this personal issue is. So you kind of talk in code, especially with someone that you're close with, a wife or a husband or longtime girlfriend or boyfriend. You kind of develop this code where you can talk about certain things even though you're in public, and people won't necessarily pick up on what you're talking about, even though it's very personal. So that's kind of what he's, again, laying the foundation for, that they're going to be hearing things like that, where these wiretaps, and they're going to be talking in these codes, and the excuse that he's going to be giving is that it's a personal phone call and it's around people, and not that they're planning a murder or that they're trying to cover up a murder, but there's just a personal thing that they're talking about. So I guess that's where he's going with that. Again, then we know that there's going to be some very nasty emails that are probably going to coming out, and conversations. So he said, has anybody ever said anything that you regretted? Of course, obviously people do that. People are always, you get into fights, you get into arguments, you're heated at a certain time, you say things that you should have never said. Everybody understands that. So you're just trying, again, just let the jury know these things you may hear. So just when I make the argument, just know that you kind of acknowledge that people say things that they regret. Okay. Anyone like to travel? Now here he's getting into the Vietnam part. Anybody like to travel? So I was wondering if he's going to bring up the one-way ticket, which he did not, which is interesting. Okay. But he could have. I think he could have. If it would have done artfully, perhaps he could have brought up the one-way ticket. Again, that's it's going to be very, very difficult to spin that one way or the other. But he did say, does anybody like to travel? And also, when you do like to travel, is it cheaper when you're going to stay for an extended time to stay by an Airbnb or to stay in a hotel? And obviously, the answer is an Airbnb. So I think we have the Vietnam cottage that Donna Adelson rented was going to be a long-time rental, so therefore it was kind of like an Airbnb, not a hotel. Okay, anyway, fine. Spoke about the nasty divorce, as Georgia Common touched on, and sometimes when you speak very poorly of somebody, doesn't mean that you're really mad at them. People get very mad at people that they love and they're very close with, but you just get into a rage about something, and you get mad, and then afterwards everyone makes up and everything's fine. So, sometimes you can speak very poorly about somebody else that you care about very deeply, but, and then you'll regret it later. It doesn't mean that you're going to kill the person, right? Okay. Has anybody jumped to conclusions before? Obviously, everyone, we always jump to conclusions at certain points. Okay. Anybody planned a party? He said. I'm not sure where he's going with this, but planning a party. Then he got into some of the definitions. Presumption of innocence. What does that mean? What does that mean to you? Presumption of innocence. And then he also said that, you have to remember that even though the state said that they have to be the ones to bring the evidence, actually the evidence comes from two places: documents that are the exhibits that are admitted into evidence, and the witness stand. That's it. Where the evidence doesn't come from the state. Evidence comes from the witness box and the exhibits that you get in court. Also remember that argument is not evidence. What I argue, what Georgia Koppelman argues, that's not evidence. Evidence is, like we said, witness testimony and documents, exhibits. And what happens if you interpret, let's say you interpret something differently than what we argue it means. Let's say there's a document, and I argue that it means one thing, and Georgia Koppelman argues that it means something else. What should he do in that type of situation? Well, what you should do is just look at the evidence by itself, ignore our arguments, and come to your own conclusion. That's essentially what he was reminding them about there. Then he got into reasonable doubt, which, again, as the defense attorney, you've got to stress, of course, during jury selection, during opening statements, during closing arguments, always stressing the extremely high burden of reasonable doubt, which he did. And he went through all the different levels of burdens of proof. So there's reasonable suspicion, there's probable cause, there's a preponderance of the evidence, there's clear and convincing. And finally, the highest level is reasonable doubt. Always a good idea, always good to start off from the beginning. I always like that approach. When you're the defense attorney, you start off from, reasonable suspicion, then then probable cause, and then preponderance of the evidence, and then clear and convincing. And then all the way at the top is reasonable doubt. And that's what they have to prove in this case. So he did a good job going through some of that. Okay, then he spoke about, again, this kind of implicit bias where when you see somebody pulled over by a police, do you automatically assume, I wonder what he did wrong? Or do you assume, maybe that he just pulled over a guy didn't do anything wrong? And our implicit, our natural knee-jerk reaction is that the guy must have done something wrong. Okay, so he also said, do you think it's not fair that the prosecutor has to prove the case and that we don't have to prove anything in this case? Do you think that that's not fair? Do you think that we should have to prove something? Do you feel that when the Donna Adelson should have to take the stand? Are you going to hold it against her if she doesn't? Even though we tell you that you can't hold it against her, but in the deep, dark, your deepest part of your mind or your heart, will you maybe hold it against my client that she doesn't take the stand? Again, these are important questions to ask. And again, if you ask the jury, even though you understand that there's going to be a jury instruction that my client does not have to take the stand, then you cannot hold it against you, right? But, is it going to tinge? Is it going to be a little bit of a pull on your heart, a little bit of a exercise for you to try to be able to quash those feelings of, I'd really like to hear from the defendant, but the fact that you didn't take the stand, I don't know, is that going to weigh at all? Just a drop? You can just, as long as you can get them to say, it may weigh a little bit. You've gotten that person. Maybe you can get strike for cause. Okay. So, but then again, that was a good line of questions that he brought out. And he went through a nice example about what does it mean reasonable doubt when you have a bank robbery and the defense gets up and argues, well, it wasn't, how do you know it wasn't my twin brother? The state didn't prove that it wasn't my twin, it wasn't the defendant's twin brother. Well, if there's no evidence that he had a twin brother, so then it's just speculative. Okay. And then he got a little bit more into what reasonable doubt means, the lack of evidence, conflict of evidence. So then that should also create reasonable doubt in your mind. And then he went on to jailhouse snitches. And we have some jailhouse snitches. I know they're the subject of a motion in front of the judge. I'm not exactly sure how it was ruling, but apparently the ruling was that these people that were with Donna Adelson, which they call jailhouse snitches, will perhaps be testifying in this case. So we may be seeing some other witnesses that we haven't seen before in Charlie's case or the other cases. So he was saying, jailhouse snitches, why would they want to cooperate with the state? Can you think of any benefit that they may get? That the state has all this power that they feel, if I help the state, then maybe they'll be sympathetic to my sentence. Maybe they'll be able to recommend a parole or something, that there's some sort of benefit to these jailhouse snitches. You have to understand that. And once you understand that, then it obviously will take away from their credibility when they talk about what Donna Adelson may have told them. Okay. Now, another thing that he brought out is the fact that the defense cannot promise anybody anything to get them to testify. Do you think that that's not fair? That the prosecution can now go and promise all types of things to people, reduce their sentences and get cooperating co-defendants, and then even jailhouse snitches, they know that they can be working for a benefit for the state, but the defense has no power at all. Do you think that that's unfair? And it doesn't really matter what they answer. The point is that you're making is that we don't have the power that the state has. We just don't have the resources that the state has. And that's something that you want to already put into the minds of the jury at this point. Okay, then he went into what does it mean to deliberate? It means to think carefully, discuss with people, make sure that you understand what your job is. And this is something also I love to stress during jury selection is that, and I also do this in closing arguments also, you have to know what your job is as the juror. I always want to tell the jurors what their job is and what their job isn't. So this is more of a general idea of what their job is. Their job is to deliberate. So, for example, in a criminal case, what you want to tell the jury is that your job is not to solve the case. They have to know this very clearly. What is your job? Your job is to weigh the prosecution's case. Your job is to figure out whether the theory of the prosecution's case makes sense within the evidence or if there is reasonable doubt. That's it. You don't have to figure out who did this. You don't have to figure out anything more. So you always want to tell the jury what their job is and what their job isn't. So this is kind of touching on this a little bit about what their job is, to deliberate, what that means, discuss with people, think carefully, reevaluate your opinions, reevaluate how you look at evidence, discuss it, be open about it. Okay. And he got into some of the examples of the rules for when you have a discussion at the dinner table. Can you accept that sometimes you don't always agree with something? And this is kind of where he's laying in or planting the seeds where maybe you may have an opinion in that deliberation room and you just will agree to disagree, which would then result in a hung jury, right? You just have to agree to disagree. And that's all I need as the defense. All you need is one or two people to say, you know what? I told Mr. Zeckelman in jury selection that if I don't agree, then I'm not going to just agree because so I can get out and have an early dinner. So therefore, coming back to what he said in jury selection, that, I've accepted, I can accept it. I will agree to disagree. So that was another point that he brought out. Okay. Also, it's the fact that you can't discuss part of your deliberations means that you cannot discuss that the defendant did not testify. You can't discuss the fact that the prosecution charged Mrs. Adelson, Donna Adelson. You cannot discuss that. Well, if they charged her, well, they must be onto something. You can't even discuss that. That's not appropriate for deliberation. So that's good. Telling the jury what their jobs are, what their job is not, what they're allowed to do, what they're not allowed to do. You're not to discuss what I'm wearing in my clothing, what my client's wearing in the clothing, how she keeps her hair, things like that. Okay, then he went into circular reasoning. How to don't just believe, good guys, people believe good guys, law enforcement are good guys. So it must be that law enforcement are believed. So he got into this whole idea that you shouldn't just accept whatever law enforcement tells you, because, they're wearing a badge and they're wearing a uniform. So therefore they should be believable and more credible. So again, this is something that Georgia Cobbman also brought out, but as a defense, you also want to let them know that, law enforcement shouldn't automatically get the benefit of the doubt that they should be believed. Then he asked an interesting question, which is common sense. I always argue the common sense instruction. It's one of my favorite instructions to always argue, and that is that you cannot check your common sense at the door. So the way that he brought this out was he asked the jury, is common sense a process or a result? Now, I don't know if he was asking this question purposely to be vague, because I don't think it's either. And I think if I was on the jury, I would say I don't think it's either. It's not a process or a result, but this is how he's asking it. And sometimes, by the way, there's a method behind the madness. And I don't know if this went into this, that you specifically sometimes ask jurors questions that don't automatically make sense. You tell them two options. Which is it, this or that? And it's really neither, but you want to see how they think. So there's a lot of psychology that goes behind a lot of this, okay? You people wouldn't believe how many books and things have been written about this. But it's possible that this is what went on. I don't know for sure, but just listening to him ask the question, he said, is it a process or a result? And discussing that idea. But to me, it's neither. It's a quality, it's an instinct, it's a practical judgment, but it's not a process. I mean, common sense is not a process you go through. It's something that you have. It's a quality that you look at certain things and you can make certain judgments based on. But anyway, doesn't matter. Okay, then he got into principle, and going over what it means to be a principal. And obviously, as a defense, you want to build up what it means to be a principal and to be able to argue that Donna Adelson is not a principal. And also the fact that her son Charlie was convicted. That doesn't mean that she's involved automatically. Just because your son's involved in something, it doesn't mean that you're involved in something. And also he brought up the fact that, and I think you kind of see where he's going to be going with this, is that kids lie to their parents. Not only do they lie to their parents when they're growing up, and this is what he brought up with the jury. Have any of you have kids? Yes. Do some of your kids ever lie to you? Do they always tell you the truth? Of course not, right? Everyone has kids that get their hands stuck in the cookie jar and they try to come up with some cockamamie excuse. So, there's always that. And on top of that, it doesn't stop when they're kids. Sometimes when they get older, believe it or not, sometimes, even when children get older, they still lie to their parents or bend the truth, right? They don't, well, it's for the benefit, of course, obviously for the benefit of the parents, but that does happen. So the point is that even if you have Charlie, and this is where kind of the argument is going to be made, it seems like, and this is perhaps a better type of argument, but the argument that looks like they're gearing up to make by the defense, by Donna Adelson, is that Charlie lied to her. That Charlie made up this whole crazy story, whatever it is, and she didn't know. She's just this poor old grandmother, have no idea about anything, and was just giving Charlie money because, I don't know, my son's asking for money. I'm not going to ask too many questions. I love him. So, here's some extra money. We have it anyway. Let's just give you some extra money. So, it seems like they're gearing up for that type of argument where he's asking these type of questions where children do lie to their parents. Also, he asked, how do people react when they're scared? Because here, big question in this case is, why didn't Donna Adelson or Charlie Adelson contact the police? Don't you think that would be a very natural reaction when you get threatened with extortion? You should go to the police. But so he's kind of making the argument already, planting the seeds for the argument that people react differently when they're scared. Some people will go to the police, some people won't. Maybe once in the Latin Kings, maybe you won't. So that's one thing. Also, and this is also seems to be like where he's going with the Vietnam trip, that not everybody wants the spotlight. When the spotlight's on you, you want to just escape. You don't want the attention. So that's one part. And then also he brought up the fact, is anyone familiar with Judaism and certain memorable events as a Jew? So this is something that I may have a little bit of experience with. But so that was another part that he wanted to bring out, that there's apparently some important events that they're going to be discussing, and he wants to know if anyone's familiar with some of those events. All right. Well, the final question I think he asked was, does anyone believe the state knows or that the state believes what happens. Does anybody here think that the state knows what happens, or does the state believe what happens? So it's all kind of the same idea, just trying to create reasonable doubt, not to just assume that the police officers know what they're talking about or the prosecution knows what they're talking about. Everything should be, you should look through a lens of skepticism and just be critical thinkers about it and make sure that the evidence actually adds up. And that's kind of what here he's going with that. So as we are recording this video, court was still in session and they're still going through jury selection. So I'm not sure where they are right now. I'm going to check. But by all reasonable inferences, they should be starting the trial tomorrow. Friday morning, we should be starting Donna Adelson's opening statements. We're going to, I guess, maybe we'll hear some of the arguments where they're already, what they're going to argue, what Donna Adelson knew or didn't know, or whether it was a double extortion or what single extortion or no extortion or just ignorant or just, who knows. But hopefully we're going to hear that during opening statements, or maybe they're going to actually save that and not give away their entire case like what happened in Charlie Adelson's case. Remember, by Charlie Adelson, Dan Rashbaum got up by opening statement and said, I'm going to tell you something that nobody ever heard before. And boom, this is what it was a double extortion. Now, I don't think he needed to do that. I think it would have been maybe perhaps more effective in just closing and not give away his whole case in opening, where now Georgia Coppin can spend the entire state's case in chief discrediting that and disproving that. But we'll see what happens, what their strategy is going to be in Donna Adelson's case. So we will see you all back here bright and early Friday morning for the continuation of Donna Adelson's jury selection, maybe, and hopefully get on to opening statements and the presentation of evidence. So that's going to be it for now. If you haven't yet, please subscribe and like, and we will see you next time.